When representation replaces evidence, the procedural problem with PGAL recommendations. There's a procedural trick that shows up again and again in child custody cases once a private guardian ad litem is appointed, and it works like this. The child is suddenly represented, which means no one else can talk to the child directly without permission of that child's lawyer, but the lawyer who represents the child then claims he or she can't disclose what the child said, citing confidentiality or hearsay, and yet the court still asks for and relies on the PGAL lawyer's recommendation. The child's voice goes in, influence comes out, and evidence never appears. This is sold as protection of children, but structurally it's a closed loop that insulates assertions from scrutiny. The court cuts off direct access to the child in the name of safety, blocks disclosure in the name of ethics, and then treats an untestable recommendation as if it were proof. That's not fact-finding, it's substitution. A recommendation untethered from admissible evidence is opinion, no matter how sincere or well-intended. And when that opinion rests on alleged child statements that no one is allowed to hear, question, or test, the ordinary safeguards of reliability collapse. This isn't about accusing anyone of bad faith, it's about recognizing a system that quietly abandons verification. Courts already have tools to hear children safely, controlled interviews, recordings, tailored questioning, but choosing instead to rely on impressions over evidence doesn't protect children. It erases them. If courts truly mean to consider a child's perspective, they have to insist on methods that actually put that perspective into the record. Anything else is theater, and children deserve better than a speaking role written and delivered by someone else.